Chairman, as I listen to these very skilled and knowledgeable witnesses, it occurs to me we're being asked to provide additional protection to the press because of the First Amendment. But it seems to me our real focus, not that the press doesn't need additional protection under SHIELD laws, ought to be on the Fourth Amendment. And I think once again, we are called to ask whether the Fourth Amendment is really still alive in the digital age. The warrant requirements and the guarantees against unreasonable search and seizures really they're foundational rights, and they're not just to the press and they're not just to members of Congress, they're to every American. And I do believe that the situation we have here is an end run on the protections that the Fourth Amendment is supposed to provide to every American. It's true that if the information sought was on a person's desktop, a warrant would have to be issued. There wouldn't be a gag order, there'd be notice. And the fact that the information is stored in the cloud instead is really meaningless. The expectation of privacy on the part of the individual is that it's their data. And I think we really need to revisit the whole scheme that we have here about Americans' expectation of privacy. When these laws were written, there was no cloud. And we ought to extend the Fourth Amendment protections to individuals' data wherever held when there is an expectation of privacy. Now, Mr. Burt, I'd like to ask you about compelling cloud providers like Microsoft to produce communication records. The Stored Communication Act allows the government to compel such data upon a showing of reasonable suspicion. Do you think that this standard is sufficient to protect the privacy rights of individuals who have their data stored in your cloud?
No, that standard is clearly not sufficient, and that's why we're recommending the heightened standard that we do recommend that the committee consider in legislative reform. That standard has then turned into these boilerplate approaches that we discussed that enable law enforcement to just simply assert a conclusion that the secrecy order is necessary. And then, as you point out, quite accurately, that denies the target of that investigation any opportunity to exercise their Fourth Amendment rights because they don't know that their property is being taken and searched and seized. What we've done in our litigation is assert our First Amendment right to inform our customers. And that, while some courts have recognized that we do have a First Amendment right to inform customers, and that's why we also believe part of the reform should clarify that that First Amendment right does exist for cloud providers, because there have been some courts that have found the opposite. We really need to ensure that citizens have the opportunity to exercise their Fourth Amendment rights, and that requires a heightened standard. It requires the specific findings of fact that a secrecy order is truly necessary under the existing statutory factors, and a record so that only in those very limited instances where it's truly necessary in the national interest is a secrecy order applied, and not 3,500 times a year just to one cloud provider.
Right now, I mean, the entire burden of protecting Fourth Amendment rights falls upon the service provider. Now, I heard your testimony that Microsoft is active in protecting those rights, but there are other providers that may not be active. The fact is, it's the individual whose rights are being challenged who should have the opportunity to contend and to protect. I'd like to think, what happens when a court issues a secrecy order that later turns out to be totally unsupported, and yet the government uses the information it gets in the request to bring a criminal prosecution? Can the defendant use the secrecy order as a basis for suppression? Do you know that?
I would yield to witness Mr. Turley to see if he's got a specific analysis of that. But I believe the answer is there is no opportunity for the defendant then to challenge that the evidence